Good afternoon, my lord.
Registrar,
Yes, my lord.
call the case.
Okay, good afternoon, my lord.
Good afternoon.
Resume at Lagos today, Wednesday, 12th of August, 2026, before His Lordship, Honorable Justice Damachi. You are most welcome, my lord. NICN/LA/389/2022 between Martins Aiko and Nigeria Bureaus PLC.
Appearances?
May my lord be pleased. Ameo Kolawole. I most humbly appear with M.O. Adejumobi, my lord, for the claimant. Lord, the claimant is present.
Okay.
We are most obliged, sir.
All right.
May it please your lordship, I am Kayode Ikumelo. My humble appearance is for the defendant. We are most grateful, my lord.
Okay. So this is a judgment between Martins Itua Arekoro and Nigerian Breweries PLC. By a general form of complaint and statement of fact dated the 11th day of October 2022, the claimant sought the following reliefs against the defendant. One, a declaration that the defendant was in breach of the terms of the claimant's employment as contained in the employee's handbook, policies, and philosophies. Two, a declaration that the 2020 end of the year appraisal of the claimant contravened his actual performance and was arbitrary, unjustified, wrongful, and contrary to fair, good, and international best practices. Three, a declaration that the claimant's performance in 2020 did not merit, and I quote, partially meet expectations rating, which made him a less valuable, unproductive, and inefficient employee qualified for redundancy. Four, a declaration that the defendant subjected the claimant to unfair, unequal, and discriminatory treatment at the workplace. And six, a declaration that the claimant's legitimate expectation of promotion and sustenance of his job merited by his outstanding performance was aborted by the arbitrary, unjustified, and wrongful appraisal of the claimant in 2020 and the consequent retrenchment. A declaration that the termination of the claimant's employment due to the unmerited, arbitrary, and unjustified appraisal was wrongful. An order mandating the defendant to substitute the false assessment in year 2020 appraisal with the end rating of outstanding or exceeding expectations. An order for damages in the sum of 1 billion naira. An order for 15% interest on judgments or multi-final liquidation of same. An order for 5 million naira cost of action against the defendant. Harmonized facts. The claimant, Martins Itua Ayikoro, whose employment with the defendant spanned from 2016 January 2007 until his disengagement on the 18th of June 2021, rose through the corporate ranks to hold the position of area sales manager for the Shugo sales area. By this suit, the claimant challenges the legality, fairness, and objectivity of his year 2020 performance appraisal rating, which categorized his performance as, and I quote, partially meets expectations, as well as his subsequent disengagement from service on the grounds of redundancy. Consequently, the claimant seeks several declaratory reliefs and order directing the defendant to upgrade his performance rating to outstanding or exceeds expectation, and substantial damages for wrongful termination and injury to his professional reputation. The core of the dispute arises from the defendant's performance evaluation of the claimant for the 2020 appraisal year. The claimant assessed that despite achieving an objective average of 111.2% across his key performance indicators under exceptionally difficult operational conditions, including COVID-19 lockdowns and NSAS protests, and receiving commendable written feedback from his direct supervisor, he was arbitrarily and maliciously rated as partially meets expectation due to personal animosity from his zonal business manager. This rating led to him being placed on a 3-month PIP commencing on 1st of March 2021. However, before the expiration of formal review of the improvement plan, the defendant terminated his employment on 18th of June 2021 on the grounds of redundancy. The claimant contends that the redundancy was a deception designed to exit him from the company, pointing that his role was never scraped but immediately filled by another employee. In response, the defendant maintains that the performance appraisal was conducted objectively and in strict compliance with the talent management policy, combining both quantitative targets and qualitative leadership expectations. The defendant argues that the rating reflected the claimant's deficiencies in people management and was validated through a multi-layered calibration process. Furthermore, the defendant contends that the redundancy exercise was a genuine operational restructuring carried out in consultation with the relevant trade unions. The defendant raises a primary defense of Estopel, asserting that because the claimant accepted his redundancy terminal benefits in the sum of 17 million naira and above, he is legally barred from challenging his disengagement. The defendant also asserts that performance appraisals are an exclusive management prerogative beyond judicial review. This court is therefore called upon to determine the propriety of the appraisal rating and the lawfulness of the subsequent redundancy disengagement. At trial, the claimant testified as the sole witness on his own behalf, adopting his written statement on oath and tendering Exhibit C1 to 11, which included his letters of appointment and termination, the employee handbook, and his 2020 performance appraisal, amongst others. I have the list of documents in the body of the judgment marked as Exhibit C1 to C11. The defendant also called a single witness, Mrs. Olufonke Odioko, its head of HR business partner for sales, who adopted a written statement on oath and tendered Exhibit D1 to 6, which included the performance improvement plan and union collective agreement, etc. Exhibit C1, D1 to 6 is in the body of the judgment. Now, I have the defendant's final written address. I will go straight to the decision of the court. In line with Section 131 of the Evidence Act 2011, the burden of proof in this suit rests on the claimant to establish his claims on the balance of probabilities. For a complete and final resolution of this dispute, this court adopts and consolidates the issues formulated by both parties. The first issue is whether the defendant's 2020 performance appraisal of the claimant was arbitrary and wrongful. Under Nigerian employment jurisprudence, the court generally respects the employer's managerial prerogative to organize his business and assess the performance of its employees. Courts will not substitute their administrative judgment for that of corporate management. They retain the jurisdiction to intervene when an internal administrative decision violates a contract, statute, company policy, or the principles of fair procedure. In Nigeria, the Supreme Court in Oforishe versus Nigerian Gas Company Limited established that where an employment contract or handbook prescribes a specific procedure or metric for performance assessment, the employer is bound to adhere strictly to it. A departure from these agreed metrics without objective justification constitutes a breach of the implied terms of mutual trust and confidence. In evaluating the evidence and facts, the defendant's performance appraisal system is governed by its 2020 talent management policy, Exhibit D3. Under paragraph 4.3 of Exhibit D3, an employee's annual assessment is based on dual metrics, the quantitative, which is the what KPIs, and the qualitative, which is the how leadership and behavior. Regarding the quantitative what metrics, the claimant's year 2020 performance appraisal report, Exhibit C4, and the testimony of CW1 established that the claimant achieved 132% on delivery, 110% on volume depletion, 104% on funding, 112% on Heineken volume depletion, and 98% on Tiger volume depletion. During cross-examination, the defendant's sole witness, DW1, admitted that the what metrics are documented without ambiguity. The mathematical average of the claimant's quantitative score is 111.2%, placing him within the outstanding or exceeds expectation tier. To justify the overall rating of partially meets expectation, PME, the defendant has stated under the qualitative how metrics that the claimant lacks leadership skills and left his sales territory in this court. This assertion is flatly contradicted by his contemporaneous documentary evidence in Exhibit C4. The written contents of the regional business manager, the claimant's direct supervisor in Exhibit C4 states, and I quote, Martin met a disgruntled team in Osogbo but now the team is united and performing better. He manages his number one distributor with tactfulness. Martin did well with his KPIs. End of quotation. The defendant also sought to justify the downgrade from an objective score of 111.2% to a partially meet expectation rating, which is 40 to 49%, by asserting that the score was the product of a multi-layered calibration process by an independent ad hoc committee. However, the defendant failed to tender any minutes, report, or records of this calibration committee to explain the downgrade. By failing to produce these vital documents, the defendant triggers the presumption under Section 167D of the Evidence Act, which provides that evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. The court therefore finds that the alleged objective calibration process is not supported by evidence. While the claimant's testimony regarding his zonal business manager's personal issues remains uncorroborated, as he failed to report the matter to management, the documentary evidence on record is, however, sufficient to prove that the 2020 appraisal was conducted and wrongfully concluded against the claimant. The defendant's departure from its own written policy in Exhibit D3 and the stark contradiction between the claimant's proven 111.2% average KPI achievement and the final partially met expectation rating renders the appraisal arbitrary, wrongful, and a breach of contract. Accordingly, issue number 1 is resolved in favor of the claimant. This court declares the claimant's 2020 partially meets expectation performance rating wrongful and void for lack of factual and contractual foundation. Now for issue number 2, whether the disengagement of the claimant under the guise of redundancy was lawful and valid. Redundancy, as defined by Section 20 sub 3 of the Labour Act 204, is an involuntary and permanent loss of employment caused by an excess of manpower. It is an operational event targeting the post, not the performance-driven assessment targeting the individual. D5 and D6 has proved that the National Union of Food, Beverage and Tobacco Employees and the defendant management had meetings on the 27th of May and the 4th of June 2021. Furthermore, to determine the validity of the redundancy exercise, this court must test it against the 3 statutory requirements of Section 30, Section 20, sub 1 of the Labour Act. The first requires consultation. The defendant tendered Exhibit D5 and D6, proving that consultations were held with the union representing the workers in the defendant company, which is the National Union of Food, Beverage and Tobacco Employees on 27 May and 4 June 2021. The claimant did not dispute these meetings, consequently agreed terminal benefits were paid in line with Section 20 of the Labour Act. This court finds compliance with this requirement. The second requirement, Section 20 sub 1 sub B, which is the last in first in principle. This principle is subject to factors such as merit, skill, ability, and reliability. While DW1 admitted under cross-examination that the claimant's post was subsequently filled by another officer, both parties remained silent on the relative seniority and recruitment timelines of the 2 officers. This court will not speculate on facts not placed before it in evidence. The third requirement, Section 20 sub 1 sub C, negotiation of redundancy payment. The parties are addendum that the claimant was paid redundancy terminal benefits in the sum of over 17 million naira at the point of exit as calculated in Exhibit D1. This requirement was fully satisfied. In view of the above, and with the objection raised, and with no objection raised, there is no doubt that the process of redundancy was aptly followed. I so find. Now, on the defendant contended that the claimant is stopped from challenging his disengagement having accepted his terminal benefit. While it is a set of principles of Nigerian labor law that an employee who accepts terminal benefits without a timely protest is stopped from challenging the validity of the termination, estoppel is an equitable doctrine that cannot be used to shield bad faith. The claimant's action primarily challenges the arbitrary bad faith performance appraisal record that damaged his professional reputation. The acceptance of redundancy severance calculation does not bar an employee from seeking judicial review and the rectification of a separate contractual flawed employment record. An employee handbook forms a binding part of the contract of service, and parties are strictly bound by its written terms under the principle of pacta sunt servanda. See Nigerian Army and Mohammed, citation provided, and Section 128 sub 1 of the Evidence Act. Consequently, once an employer places an employee on PIP for a specified duration, it creates a contractually binding obligation and a legitimate expectation that the employee will be allowed the full period to remediate any perceived deficiencies. Bypassing or truncating this process prematurely to effect a termination constitutes a unilateral breach of the employment contract. The record shows that the claimant's PIP was scheduled to run from the first day of March 2021 to 30th day of June 2021. However, the defendant aborted this process and issued the letter of termination Exhibit D1 on 16th of June 2021, effective 18th of June 2021, while the redundancy exercise was concurrently ongoing. Ordinarily, terminating an employee on performance grounds before the expiration of an active PIP violates contractually binding guidelines. However, because a collective redundancy process was concurrently underway and negotiated with the union representing the workers, it is the holding of this court that the defendant retained the administrative right to execute the redundancy, which took precedence over the individual performance management tract. Consistent with the rule against judicial interference in the internal management of a corporation, this court will not micromanage the administrative timelines of the defendant, particularly where the relevant trade union participated in the redundancy process and ensured the claimant's exit payments were negotiated and settled. The court therefore finds that the termination of the PIP session midway was contractually irregular. However, the concurrent redundancy exercise complied with the key statutory requirements of the Labour Act and was concluded with the trade union participation and the payment of severance benefit. Accordingly, issue number 2 is resolved in favor of the defendant. In view of the above, I therefore made the following orders. Relief 2, 3, 5, 6 is granted to the extent that the defendant's performance appraisal rating of the claimant for the 2020 appraisal year as partially meets expectation, developing or not always meeting expectation, and at career level/lateral potential was arbitrary, unfair, and a breach of the defendant's talent management policy. For reliefs 1, 4, 7, they are all declined. In relief 8, claimant seeks for damages in the tune of 1 billion naira. Under Nigerian law, the rule for claiming damages for breach of contract is anchored on the principle of restitutio in integrum. That's restoration of the original position. The objective is to place the injured party so far as money can do it in the same position they would have been had the contract been performed. The governing rule is a common law rule in Hadley and Baxendale, which has been fully adopted by the Nigerian courts, including the Supreme Court in GKF Investment Nigeria Limited and Nigerian Telecoms PLC and UBN and JERIC. The rule divides recovery damages into 2 limbs. The first limb, which is the general damages that arise naturally according to the usual course of things from the breach itself. They are the direct and immediate consequence of the breach and do not require special proof or prior contemplation. The second limb, which is the special damages that do not arise naturally but arise from unusual or special circumstances, they are only recoverable if the special circumstances were within the actual or reasonable contemplation of both parties at the time they entered into the contract as a probable result of a breach. To claim under this limb, the special circumstances must have been communicated to the defendant and the loss must be specially pleaded and strictly proved. A key accompanying rule is that the court will not award damages for losses that are too remote. The loss must be a direct result of the breach. The court will not award both general and special damages for the same breach if doing so would amount to double compensation for the same loss. See Agbenelo and UBN. In the instant case, the claim for 1 billion naira, besides being extreme, the claimant has not shown this court by tendering any evidence how the 2020 performance appraisal rating affected him personally or his career progression. It is on record and was equally admitted by the claimant that he got another job. The general damages for 1 billion naira has not been justified and is hereby declined. Courts follow events. In view of the declarations earlier made in favor of the claimant, cost of this suit is assessed at 500,000 naira only. The sum awarded shall be paid in 30 days, failure of which interest at the rate of 10% per annum shall accrue until the entire sum is fully liquidated. This is the judgment of the court.
As a court, please. My Lord, we are very grateful, sir. We are very grateful for the industry put into the judgment. Grateful, sir.
Thank you, my Lord.
I'm most grateful, my Lord.